Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez. Here. Assemblywoman Hanson. Assemblywoman Hardy. Here. Assemblywoman Kasama. Here. Assemblywoman Kresner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill. Here. Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
I am here. Please mark Assemblywoman Hanson absent, excused. Everyone else is here with us this morning. We do have a quorum, so good morning to everyone here on the committee. Good morning to those joining us here in the room in Carson City and to those who are on the Zoom, as well as those who may be watching on the internet or the legislature's YouTube channel. We have arrived at day 80 of the 81st session of the Nevada Legislature, which means we are 2/3 of the way there. So yes, pat yourself on the back. So before we move to our agenda, just a few housekeeping matters. For those who are in the room with us, if you could please silence your electronic devices. If you are in the room with us and you're going to testify on a bill today, when you come to the table, please make sure to turn the microphone on and clearly state your name before you speak, and then please turn the microphone off when you are done speaking. For those who are on the Zoom, if you could please mute yourself as well when you're not speaking. And most importantly, if you could remember to state your name each time before you speak, particularly when you're answering questions, that'll help us prepare accurate committee minutes. In addition, we expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly acceptable, but we need to make sure we're being respectful of one another, of the legislative institution, and most importantly, of our very hardworking staff. And then finally, many members have multiple devices in front of them to access this meeting, to access exhibits, so please don't see it as a sign of disrespect or inattention if members appear to be looking away. With those matters behind us, we're going to move to our agenda. Members, we're going to take the bills in the order as listed on the agenda this morning. So I'm going to now open the hearing on Senate Bill 7 in its first reprint. That bill makes various changes to the jurisdiction of certain courts relating to certain orders for protection where the adverse party is a child under 18 years of age. I believe we have Judge Saragosa with us and Mr. McCormick with us, both here on the Zoom. Good morning. Welcome to Assembly Judiciary, and please proceed with your presentation, and then I'm sure we'll have some questions.
Good morning, Chair Yeager and members of the Judiciary Committee. My name is Melissa Saragosa. I'm the Chief Judge of the Las Vegas Justice Court. I'm here today to present to you Senate Bill 7. Existing law provides for several different types of protective orders. Some of those fall within the jurisdiction of the Justice Courts. For example, protective orders against stalking and harassment in the workplace, and orders for the protection of minors. Others, depending upon population, fall within the district court's jurisdiction. For example, protection against domestic violence and protection against high-risk behavior, though that's not an exhaustive list. This particular bill addresses a gap that the court feels needs clarity. While our existing laws address the subject matter of the different types of protection orders, it does not address the personal jurisdiction over the adverse party against whom the protection order is sought, particularly juveniles. Though not a large number of cases by any means, the law is simply just not clear on which court should handle that application for a protection order where the adverse party is a juvenile. And this bill is intended to clarify that jurisdiction should lie with the district court, as that court should have exclusive jurisdiction over a juvenile. One of the issues that arises is that our customer needs to know where to file the particular application. And in general, a violation of such a protection order would be handled as either a new criminal matter, which would be handled as a juvenile delinquency matter, or the court could handle that as a matter of contempt. Because contempt carries the possibility of jail time, we feel the law should be clear that these should again fall within the district court rather than the justice court, who does not handle juvenile matters, especially when the possibility of jail time is presented. Section 1 of the bill makes this jurisdictional clarification. It allows the district court to appoint counsel for a juvenile adverse party. It provides for the manner of service of an order of protection. It also provides for the automatic sealing of the protection order record, and that does not exist in the justice court type protection orders. Should the adverse party wish to seal the record prior to the automatic date identified in this bill at the age of 21, there already exists a procedure for the adverse party to request sealing prior to that date under NRS 62H 130. Section 2 clarifies the justice court's jurisdiction by exempting cases where the adverse party is under 18. And Section 3 of the bill sets forth the inapplicability of the provisions to existing protection orders. That concludes my presentation and overview of the bill, and I'm happy to answer any questions as well as Mr. McCormick.
Thank you so much, Judge Saragosa. Mr. McCormick, did you have any remarks at this time, or did you want to go to questions?
Thank you, Mr. Chair. John McCormick, for the record. I don't have any specific remarks at this point. Would be happy to answer questions.
Okay, thank you both. Committee, do we have questions? We'll start with Assemblywoman Bilbray Axelrod, and then we'll go to Assemblywoman Marzola.
Thank you, Mr. Speaker, and thank you for bringing this bill. I am just curious, because this is not my wheelhouse, as I've begun saying a lot in this committee. What happens now? So I'm imagining, because it's not put in statute, people are going to different places, or is it different in different counties, or what's it look like now?
John, do you want me to handle that question?
Sure.
This is Judge Saragosa again. You're exactly right. It happens differently in all the jurisdictions. I can tell you we've encountered a scenario in the South where we received a case with a juvenile adverse party, and one of our judges wrote an order transferring that matter to the juvenile division of the district court, and then it got sent back to us saying, no, we don't have jurisdiction over this, it's a juvenile. And the juvenile court gets it and says, we don't have jurisdiction over this, it's a stalking and harassment TPO. So there's that kind of, I don't know, we don't know. The judiciary doesn't know where the legislature wants those cases to lie. We've now kind of had months of talking this out. There was a similar bill last session where we needed to tweak it a little bit. We brought it back this time after discussion, and now we have discussed with the juvenile delinquency judges within the 8th Judicial District Court as well as the 2nd Judicial District Court, and across the judiciary we feel that this is an appropriate resolution to the issue.
Thank you.
We'll go next to Assemblywoman Marzola.
Thank you, Chair, and thank you for bringing this bill. My question is in regards to Section 1, subsection 2, where it states the district court may, at its discretion, appoint counsel for a child, and I'm wondering why it's not shall to make it mandatory, especially because we are talking about a minor.
Thank you, Assemblywoman John McCormick, for the record. When this was written, I kind of stole from Ohio, and that's how they had it. We don't have a particularly strong opinion either way on that. I think the court has the authority to appoint counsel as they see fit, and since this is not a delinquency proceeding, the actual petition for the protective order is a civil proceeding. There's not the requirement under Gideon that counsel be appointed. So we left it permissive in the statute. There's also some concern from the public defender's offices about this, and it's my understanding that the Washoe County PD and the Clark County PD don't necessarily agree on this. So we thought it best to leave it permissive at this point.
So what happens if a child shows up without an attorney at that point? Does... I'm sorry, go ahead.
Sorry again, John McCormick for the record. If the child were to show up at a hearing without counsel, they would kind of be there on their own necessarily without appointed counsel. Hopefully they would have a parent or guardian with them. But generally in that circumstance, I think the courts would default to appointing counsel for a child.
Do you think that wording would be able to be changed from may to shall, or make it mandatory for an attorney to be appointed in those cases?
Again, John McCormick for the record. Yeah, I don't believe that the judiciary would have necessarily an issue with that. Again, I think the concern would come from the public defender's offices.
Okay, thank you. Thank you, Chair.
And before I go to our next question, because it's on this line of questioning, let me just ask this: if you guys know, I mean, how many cases are we talking about where we have minors involved in orders for protection? Are we talking a handful, or are we talking hundreds, thousands? If you could give me any sense. I know, Judge Zaragoza, you obviously are down in Clark County, and that's where the bulk of the population is. But if you have some insight, I think that might help us on this council question.
Yes, Chair Yeager, this is Judge Zaragoza again. You're correct. It's a small number, and we're talking a handful. Previously, we had not had any sort of data mechanism in our case management system to pinpoint those, but through conversations with the various judges, I've attempted to extract that information by way of just query. And I would say it's less than 10 a year, easily less than 10 a year.
Thank you. We'll go next to Vice Chair Nguyen, please. Or Mr. McCormick, did you want to add something?
Thank you, Mr. Chair. John McCormick for the record. Again, I was just going to say that anecdotally, it's a very small number across the state. In rural counties, it's an issue because there are so few and there's no statutory guidance on who should do it. And so it happens so rarely that folks are like, what are we supposed to do? So again, I think anecdotally across the state, there's not a very high number of these cases.
Thank you. Vice Chair Nguyen?
Thank you, Chair. And thank you again for bringing this back. I know that it was brought in 2019, and it clearly is a large topic that has lots of different stakeholders involved and gets very complicated very quickly. I kind of agree with the idea that these children need like counsel in these kind of situations, because in talking with the judges, some of these cases are like kids seeking TPOs against other kids in certain circumstances. Isn't that correct?
Yes, that is correct. This is Judge Zaragoza again.
And then sometimes it's even parents seeking like TPOs against like a friend's child from a school too. I've seen those kind of situations in talking with some of the judges as well.
And if I may comment on that briefly, there is a specific, and this is a very unique area, there's a specific mechanism and statute that allows for an adult or parent guardian of a minor to file an application for the protection of a minor. But that statute actually states that it has to be filed against an adverse party who's over the age of 18. So that kind of gap is there uniquely as well. And this particular bill would also kind of cover that, because it would now make it clear that if the adverse party is under 18, it would go to the district court. But the Justice Court currently doesn't hear those. If there was a parent seeking protection of their minor child against another minor child, they couldn't file in Justice Court because of that statute.
And then just another question regarding that. So would the parent now has the ability to file that TPO on behalf of their minor child? Is that correct?
Yes, that is correct.
And then and I know that this was an issue, and I don't know if it's clarified or how this has come about, but I know that as it currently stands, it's an interesting situation. So if I go get a TPO against another child on behalf of my child, so I'm asking for a TPO for my child against another child, and how is that TPO, like if it's granted, how is it, like whose record is it on? Does it still go on the guardian or the parent's like record? So it looks like the parent has like a TPO on their record. How is that working now?
Assemblywoman, again, John McCormick for the record. Currently, there's no specific statutory grant of authority to issue a protection order against a person under 18. So in that scenario, the existing mechanism, and Judge Zaragoza, please correct me if I get out of line here, is that protection of minors, TPO type, where the parent of the protected child would apply in justice court against the parent of the other party, because there is no specific statutory mechanism to apply for a protection order against a minor, and there's that, thus the genesis of this bill. So in that case, because the justice court could not issue a protection order against a minor, it would have to be against the guardian, the parent or guardian of the other party. So that becomes problematic there, because I certainly can understand that a parent applies for an order on behalf of their child and against, behavior from another child, but currently statutorily, that order would be issued against the parent, and depending on that family dynamics, that could obviously be problematic for the parent.
Thank you.
We're going to go next to Assemblywoman Gonzalez, who I think has 2 questions.
Yes, thank you so much, Chair. Assemblywoman Gonzalez, District 16 for the record. My first question is, in Section 3, when it lists out the protection order, so domestic violence, harassment in the workplace, high-risk behavior, sexual assault, stalking, etc., is that saying that these are the only instances in which a protection order can be used for someone under 18?
Thank you, Assemblywoman. For the record, John McCormick, those are the current existing protection order types in statute. So this bill just clarifies that if a person is seeking one of those types of protection orders against a minor, it would be heard by district court. Again, other injunctive relief could be sought through the court, but those are the statutorily authorized protection order types that we currently have.
Okay, and thank you so much, Assemblywoman Gonzalez, District 16 for the record. What happens if a child violates this type of protection order?
Thank you, Assemblywoman, again for the record, John McCormick. If a child violates this type of order, currently it's contemplated in Title V, so Chapter 62, A, B, so forth, dealing with juvenile justice, that the juvenile court would have jurisdiction over that, because it would then become a delinquency matter, meaning that if a child violates and they were an adult, it would be a criminal matter, so it would then become delinquency for the juvenile court to handle.
Thank you.
Assemblyman O'Neill, did you have a question?
Thank you, Chair. Actually, I may have a couple questions. The first one, if a juvenile is emancipated, who has jurisdiction? Does he still stay, she still stay within juvenile court, or do they move up to adults as an emancipated person?
John McCormick for the record. Honestly, I am not 100% sure on that. I don't know enough about emancipation to know if that individual is then after they are emancipated, if they're then treated as an adult for legal purposes, then I would imagine it would be the regular jurisdiction, but maybe Judge Zaragoza has a better idea. Not to punt, but no.
This is Judge Zaragoza. I wish I did have a better answer. I'm not clear on that either, because the Justice Court does not handle juvenile matters as the exclusive jurisdiction, original and exclusive jurisdiction over criminal acts committed by minors exists in the juvenile court. I know they have a procedure in the juvenile court where the case is evaluated and based upon the juvenile's record as well as the charged potential offense. The juvenile court may elect to treat them as an adult, and maybe that's one of the factors they consider, but I'm not aware of any specific statute that would say just because the child chooses to be emancipated and then there's a criminal act, say a violation of a protective order, that they would automatically be treated as an adult. I'm not aware of anything like that.
And again, John McCormick for the record, Assemblyman O'Neill, I just actually pulled up the statute, and I believe that would be governed by NRS 129, 130, and it it appears that the person would still be considered delinquent under Title V if they were emancipated and under the age of 18, unless otherwise provided by the court's decree emancipating them.
So, if I may, maybe I wasn't clear enough. So for the TPO, would that emancipated juvenile have to go before juvenile or over to JP court? If there's a juvenile, I want to get a TPO on them, which court do I go to? That's where I was going. I'm
John-
sorry.
Sorry, John McCormick for the record. In light of 129.130, it appears that that would be an individual case for emancipated minors. Based on the statute, it looks like that you would still go to the district court to ask for protection order against someone 18 or younger who was emancipated, unless the specific decree emancipating that minor said otherwise.
Wow. Thank you. Can I ask one more follow-up? So let me ask you, you get a TPO on a juvenile, go to this legislation, excuse me, legislation passes, you go to juvenile court. They're 18, 17 years old. When they now become an adult, should you then go before JP court to get a continuation of your TPO? It would seem to me that'd only be right. Now they're under adult statutes, that you should go forward to JP just to have them certify or review. Or you're
Thank you,
saying they
Senator.
still stay under, even though they're an adult, they still stay under the juvenile court system?
Thank you, Senator. For the record, John McCormick. In subsection 5 of section 1 in this bill, it provides that if the district court issues an order pursuant to the act and the adverse party reaches the age of 18 while the order is still effective, the order remains effective against the adverse party until the order expires or is dissolved by the court. So in a specific instance where it was issued against a 17-year-old who then turned 18, the order of the juvenile court, or the district court in this case, would remain in effect until it expires or it's otherwise dissolved for continuity. So the protected party would not then have to monitor the birthday, per se, of the adverse party. But then if they sought another order after the expiration of this order as provided in statute, they would then go to the justice court or the district court, depending on which county they live in and what type of order they're looking for.
Thank you. Thank you, Chair.
All right, we have a few more questions yet. We'll go next to Assemblywoman Summers Armstrong.
Thank you, Chair. My question has been asked and answered.
Thank you, Assemblywoman. Then we'll go next to Assemblywoman Kasama.
Thank you, Assemblywoman Kasama, District 2, for the record. Just two clarification questions, if I may. So with this this new language, the TPO would actually be served against the child and not the parent anymore, which was the problem before. Is that correct? In the example you gave.
John McCormick for the record. In the previous example, if it was under the specific statutory provision that allows justice court to issue an order for protection of minor, that can't be issued against a minor in the statute, so it would go against the parent. In this specific bill where we're seeking to clarify that, we provide that if the district court issues a protective order against the minor, that it has to be served against the minor as well as that minor's parent or guardian. So everybody receives adequate service.
Okay, great, thank you, just wanted to clarify that. And then back to Section 1, subsection 2, where we had the discussion regarding the district court may or shall. Because it seems to me if a parent and a child came in our example, wanted to do a TPO, we don't really have to appoint counsel. So if we have shall, then it would force a counsel to be there. So if we leave it at may, then it could just be the parent and the child that comes in and asks for the TPO, and it can be handled that way. Is that correct?
Thank you, Assemblywoman Joan McCormick, for the record. The provision regarding appointment of counsel applies to the adverse party, so the juvenile against whom the order is sought. There would be no requirement to appoint counsel, nor would the potential protected party or the parent or guardian need counsel. So that provision of this bill only refers to the potential adverse party against whom the order is sought.
And if they have their parent that is there with them, when, let's say it's the adverse party, they might be able to handle it, because if we put shall, then you have to have a legal counsel. Is that correct?
For the record, John McCormick, I believe, yes, if the language is changed to shall, the court would then appoint counsel for that minor adverse party, regardless of whether or not a parent or guardian was there. If it were may, as it is currently written, the court would make the determination on whether or not to appoint counsel for that potential minor adverse party.
Thank you.
Go next to Assemblywoman Cohen.
Thank you, Chair, and thank you both for the presentation. My question is about one family, one judge, and if this would invoke one family, one judge, so that if there's a TPO for a minor, it goes to family court, and now you've kind of got one family, one judge set up. And so 5 years later, 3 years later, when the parents have a custody issue, are we stuck under that, or will it just start a new case? Well, obviously it'll start a new case. I know it'll be a new case number, but will you be required to go before that same judge? And I know that's a local court rule issue, but I want to make sure we're not kind of doing an unintended consequence that we're not thinking of.
Right.
Thank you, Assemblywoman John McCormick, for the record. Since it is a local issue, I think that this bill is mum on that, and the specific court could make that determination as far as the family court in the 8th or the family court in the 2nd. In the rurals, it's a good chance it's going to be the same judge regardless. Again, I don't necessarily think we contemplated the one family, one judge project here, but again, I think that would be a decision made by the local jurisdiction.
This is Judge Zaragoza. I would also point out that Section 1, Paragraph 7 authorizes the district court to appoint a master to conduct these proceedings. In general, at least in the South, most of the protective order proceedings, even when they're domestic violence related, are handled by a master, not by the judge who would preside over the any issues relating to child custody or divorce. Likewise, if there was a juvenile delinquency matter where there was a criminal charge brought against a juvenile adverse party for violating this order, that would go before the judge who handles juvenile delinquency matters, which may or may not be a master. So I'm not sure that this bill at all in its form, because it doesn't always just involve family members. The applicant is someone outside of the family, generally speaking. So I don't know that concept would necessarily be driven by this particular bill.
And thank you for that. But even with the hearing masters, there's still a district court judge who's considered the judge on the case. And so if you do have a TPO and then you have a custody matter that opens as a new case, you end up in the same department. So I would just ask, and maybe I'll work with counsel and can talk to you more offline and talk to the committee counsel if we could maybe, if this bill goes forward, do some sort of amendment that makes that clear, that that's not necessarily required, because I just don't want to have practitioners and families have issues in the future that are unintended, and make sure that that's clear that that's not what this is doing, and not have to have a rewrite of the EDCR 5, as they've been working on that for a couple of years now and have finally gotten to the place where some of those sections are done. And so I'll just follow up online, but thank you.
Go back to Assemblywoman Gonzalez for a question.
Thank you, Chair. Assemblywoman Gonzalez, District 16 for the record. So I just wanted to clarify, we don't know what the penalties are if a juvenile were to violate a TPO, and or is that not in statute?
Thank you, Assemblywoman John McCormick, for the record. The penalties for those acts, if they were committed by an adult, are provided in statute. So it would be as if any offense were committed by a juvenile considered by the juvenile court under Title V. It would be not a criminal act, obviously, but a delinquent act, and then the court would consider that matter as it would any other delinquent act.
Sorry, follow-up, Chair. So we are saying that this is a delinquent act because if you are an adult, it would be a criminal act, right?
For the record, John McCormick, yes, ma'am. In Title V, the juvenile justice title, it's contemplated there are two types of juvenile offenses, if you will. There's a status offense, which is an offense because of the individual's age, and we call that a child in need of supervision. And then we have a delinquent act, which, if but for the age of the individual, would be a criminal act. So being that violation of these orders is considered a crime in the adult world, this is a delinquent act because it would be a minor committing an act that would be a crime if they were an adult.
Okay, sorry, just clarifying. So this bill states that it would be a delinquent act. Are you saying refer back to Title V?
Thank you, John McCormick. For the record, in sub 4 of section 1, the juvenile court has exclusive jurisdiction over any action in which it is alleged the child who is the adverse party to an order has committed a delinquent act by violating conditions set forth. So it is a delinquent act because in this bill, because if it were committed by an adult, it would be a criminal act. So it's delinquent by virtue of this bill and because of by the nature of the act.
Sorry, Chair, may I follow up? Sorry, so would the courts be open to changing this or maybe, I kind of just worry when we continue to criminalize juveniles, and so I get a little worried when we, they violate this TPO, and because it's criminal in adult court, it doesn't necessarily translate over in juvenile court. So I'm just curious, is there any openness to whether it be a juvenile or a delinquent act versus a status offense? And or do you guys take different types of violations into consideration?
John McCormick, for the record, I think whether or not a violation of that order is considered a child in need of supervision or a delinquent act is sort of a policy decision for the legislature to determine. The reason it is a delinquent act in this bill is because it would be a delinquent act under our current statutory scheme. And in this bill, we didn't seek to change any aspect of juvenile court aside from the fact of granting specific jurisdiction for these orders to the district court.
Thank you.
Okay, before we take testimony, I just have one last question I want to ask. And so, under the current law, as I believe it exists today, the testimony was that the order of protection is actually issued against the parent because you're not authorized to issue one against a minor. So, under current law, if the order is issued against the parent, but the minor violates the order, is the minor held accountable in some way, or is it the parent who has to come forward and sort of take the heat and explain what happened? And I just wondered if you could talk about how that works right now so we can get a sense of what would happen if we didn't pass this bill, what the status quo is.
Chair Yeager, this is Judge Zaragoza, and I'd like to respond to that. I think that's one of the issues. It's different across the state because the Justice Court, when we've gotten those and we've sent them to juvenile court and then received them back again, we issue the order in the name of the juvenile. We have jurisdiction over applications for protective orders against stalking and harassment, and while there's no specific age limit on a civil type TPO action, we would have issued that TPO against the juvenile and treated it just like an adult. And that's the rub. That's the uncomfortable nature of a justice court judge trying to handle this as a juvenile matter. So in our court, we've never issued the protective order against the parent. But I do know that across the state, there's different ways and other jurisdictions have handled it that way. And if I may, I just wanted to clarify one point that I believe I misspoke on. Vice Chair Wynn asked about whether or not this bill would allow a parent of a minor to seek a protective order for the protection of a child against another minor. And I said originally, yes, that it does. And I misspoke slightly. It will in all natures of, protection order against sex assault, protection order against stalking and harassment, all of the other types, except for that which is protection order for children. And the reason for that is because under NRS 33.400, it states today and continues to state that the parent or guardian of a child may petition any court of competent jurisdiction on behalf of the child for a temporary or extended order against a person who is 18 years of age or older and who the parent or guardian reasonably believes has committed or is committing a crime, and then it lists the nature of offenses. So that's the unique part about that statute, and the way it currently reads is it requires it to be filed against a person who's 18 years of age or older. So there would never be the occasion to file that against a juvenile in juvenile court. Though a parent or guardian who's seeking protection for their child against another minor who has committed a sex assault or domestic violence related or harassment and stalking or high risk behavior, all of those things would still be able to be sought in the juvenile court against a juvenile. And I hope that clarifies it.
Thank you, Judge Zaragoza. Go ahead, Mr. McCormick.
I was just going to follow up on that, Mr. Chair. And again, I think Judge Zaragoza indicated that we're seeking to fill that sort of gap in statute, because in a jurisdiction where, say, a court were with lack of guidance to issue an order against the parent of another child, thinking that was what was statutorily permissible, then it would depend on the violation. And most courts would be, anecdotally, again, conversations would be very reticent to impose sanctions on a parent for behavior of a child that violates the order. So again, this bill seeks to close that sort of question.
Thank you. And I think in the interest of time, we'll move on. And I know, Judge Zaragoza, I believe you have to step out soon. So if you need to excuse yourself from the meeting, that's perfectly fine. I'm sure Mr. McCormick can handle any concluding remarks, and we certainly appreciate both of you presenting the bill this morning. So at this time, what I'm going to do is ask you to sit tight. We'll take some testimony on the bill, and then we'll come back for any concluding remarks. I will now open it up for testimony in support of Senate Bill 7. Is there anyone here in the room with us in Carson City who'd like to testify in support? Right, I don't see anyone coming forward. Let me check the Zoom, please. Is there anyone on the Zoom with us who would like to testify in support? If so, if you could please unmute yourself and let me know you'd like to testify. Okay, I'm not hearing any activity on the Zoom. BPS, could we go to the phone line to see if there's anybody there in support?
Good morning. Thank you, Chair. For callers wishing to testify in support of Senate Bill 7, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in support of Senate Bill 7, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you so much, BPS. I'll close testimony in support. I will now open it up for testimony in opposition, and we'll start here in Carson City. Good morning, Ms. Birchie. Welcome, and please provide your testimony.
Good morning, Kendra Birchie with the Washoe County Public Defender's Office. Due to the rules of the committee, I am testifying in opposition here today. I want to first thank the sponsors for speaking with myself and Mr. Pirro on several occasions regarding this very important bill. We understand the need for uniformity and to ensure that there is some accountability. I provided an amendment that's been uploaded on Nellis. Our first concern is regarding the appointment of counsel. We believe that all children who are involved in the TPO process that are adverse parties should be required to have counsel. As you heard, these are potentially criminal matters in terms of they would be delinquent matters. They could be before the court, where if there's any form of violation, they could be subject to going to juvenile hall. And so we believe that it is extremely important to have counsel appointed for those adverse parties. In the amendment, I specified either when a hearing occurs or upon the issuance. That would mean that when there is an issuance of a temporary protective order, that counsel would be appointed so that counsel could speak to that individual and let them know what the requirements are, how to ensure that they do not violate that order. So hopefully there won't even be a need to have that become a delinquent act. We believe that this would hopefully help to ensure that there aren't any of the collateral consequences regarding that issuance. I would just note that although this is a procedural change in order to just really clarify who has jurisdictions, we do have a lot of concerns regarding having juveniles involved in TPOs, specifically with the with having the applicant an invited contact. That's one of the issues that we see currently with adults in the temporary protective orders and extended protective orders, where the applicant will be the one to initiate contact, and then it's the adverse party who's then held accountable for that contact if they then continue with that. So if the applicant reaches out then after the issuance of the temporary protective order, and that could be a violation if the adverse party then responds. And in the age of social media and all that, we just do have concerns, and so I need to note that concern. Then for the amendment number 2 and 3, we do have concerns with the with this information staying on the child's record until the age of 21. We believe that it should be 18 unless it's dissolved sooner. So the second amendment that I propose would just require that the information be sealed earlier upon the expiration of the order. For example, if it's just a temporary order, that it doesn't get extended, that it gets automatically sealed at that time and taken off of that child's record. And the third would just allow for a process where the child could petition to make sure that that information is not in the central repository. So we believe that these amendments are necessary in order to ensure that our children are protected. Thank you.
Thank you for your testimony, Ms. Birchie. Is there anybody else here in Carson City who'd like to testify in opposition? Okay, I don't see anyone coming to the table. Let me take a quick look at our Zoom. Is there anyone on the Zoom who would like to testify in opposition? If so, if you could please unmute yourself and let me know. I don't hear anyone on the Zoom. BPS, could we go to the phone lines to take opposition testimony there, please?
Thank you, Chair. For callers wishing to testify in opposition of Senate Bill 7, please press star 9 now to take your place in the queue. For callers wishing to testify in opposition of Senate Bill 7, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open it for neutral testimony. Is there anyone here in Carson City who'd like to testify in the neutral position? Nobody's coming to the table here in Carson City. Let me check our Zoom. Is there anyone on the Zoom in the neutral position? I don't believe there is. So BPS, could we go to the phone lines to see if there's neutral testimony, please?
Yes, Chair. For callers wishing to testify in neutral of Senate Bill 7, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 611. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Pirro from the Clark County Public Defender's Office. I had heard some of the questions regarding the may and shall as far as appointing counsel. I know this is a policy committee, and we agree with the policy of making sure any kid pulled into the juvenile justice system is appointed an attorney. The only thing that I will make the committee aware of is that will probably trigger an unsolicited fiscal note from Clark County, because although anecdotally the Justice Court says that they don't think it will increase caseloads, they haven't been keeping data, which is problematic that we never really have criminal justice data when we need it. But that will increase court appearances and caseloads for our juvenile attorneys. And we're more than happy to do that with extra attorneys. Thank you.
Thank you for your testimony, Mr. Pirro. BPS, are there additional callers in the neutral position?
Chair, there are no further callers at this time.
Thank you so much, BPS. I'll close neutral testimony, and I will now hand it back to our bill presenters for any concluding remarks on Senate Bill 7.
Thank you, Mr. Chair. John McCormick for the record. Judge Zaragoza had to leave for another obligation. I would just like to thank the committee for hearing this bill and indicate that I believe Ms. Birchie's amendments are sort of policy questions. We're not opposed to them if the committee were to choose to adopt them. And our only concern would be making the ceiling age consistent. I believe in her amendment, it's 18. Currently in statute, it's 21, but it's my understanding that the legislature is processing a bill that would lower that age to 18. So our only concern would be to have the ceiling age be the same for all juvenile records, as opposed to having, TPOs at one age and delinquency or status offense records at another age.
Thank you so much, Mr. McCormick, and I believe that's Assemblywoman Krasner's bill you referenced that I think we passed out on the floor yesterday. So we'll monitor these things going forward. Obviously, these bills on our side have to go through the Senate process as well, but appreciate your willingness to work with Ms. Birchie on her concerns, and please express to Judge Zaragoza, I appreciate that as well. Thank you to both you and her for being here this morning, and I hope you have a great rest of the day. So at this time, I will close the hearing on Senate Bill 7, and we'll move to our second bill on the agenda. I will now open the hearing on Senate Bill 19 in its first reprint. That bill establishes provisions authorizing certain entities to obtain information relating to the records of criminal history of certain persons responsible for the safety and well-being of children, elderly persons, or persons with disabilities. And I believe we have Ms. Silva from the Nevada Department of Public Safety with us here on the Zoom this morning. Thank you for joining us, Ms. Silva. We'll give you a chance to go through the bill, and then I'm sure we'll have some questions. So please proceed.
Perfect. Thank you. Let's see. Good morning, Chair Yeager and members of the committee. I'm Amanda Silva, an INCEGIS Program Specialist Supervisor for the INCEGIS Compliance Unit with the Department of Public Safety, Records, Communications, and Compliance Division. And I'm here today to introduce Senate Bill 19 to the committee. The Records, Communications, and Compliance Division houses the central repository for Nevada records of criminal history, which maintains statewide records of Nevada arrests and dispositions, and is also responsible for processing fingerprint-based background checks for civil purposes to include licensing, employment, and volunteers. Section 1 of this bill is proposed in an effort to ensure the continuation of fingerprint-based background checks on individuals working and/or volunteering to work with our state's most vulnerable population, which is children, elderly, and individuals with disabilities. In order for an entity to have access to state and FBI criminal history record information, a federal or legislative authority must exist specifying this access. Currently, background checks for this population are being conducted under the federal authority National Child Protection Act as amended by the Volunteers for Children Act, also known as NCPA-VCA. It is important to note that this federal authority can only be utilized in the absence of a state statutory authority. This bill does not give fingerprinting authority in itself, but rather ensures that Nevada does not lose access to the federal fingerprint authority. This authority bridges the gap, allowing access to fingerprint-based background checks to agencies working with vulnerable population who do not otherwise qualify for a state statutory authority. Until 2019, the FBI allowed states to utilize this federal authority in the absence of a state statutory authority. In January of 2019, the FBI issued a notification to all states regarding amendments to the NCPA-VCA authority, which now require states to have a state statute that authorizes the national background check of covered individuals in order to continue utilizing the NCPA-VCA authority. The Records, Communications, and Compliance Division currently has 333 active accounts that utilize the NCPA-VCA. In 2019, the division received 13,256 NCPA-VCA fingerprint submissions, and in 2020, we received 8,821. Should Nevada lose its authority to conduct national background checks utilizing the NCPA-VCA due to lack state statutory authority, if this bill is not passed, those account holders would be adversely impacted as our office would be required to close the accounts due to lack of fingerprinting authority, thus placing Nevada's vulnerable population at risk. Therefore, this bill seeks to enact state statutory authority to allow Nevada to continue utilizing the federal fingerprinting authority, NCPA-VCA, pursuant to Public Law 103-209. In summary, this bill will not change the way that we process these background checks, but rather will allow Nevada to continue utilizing this federal authority to protect Nevada's most vulnerable population. With that, I request the committee's support for Senate Bill 19, and I'm happy to answer any questions that the committee may have. As always, we're happy to meet with any of you regarding any of our important programs, so please never hesitate to reach out to us at any time. Thank you for your time today.
Thank you so much for your presentation, Ms. Silva. Let me just ask a question to make sure I understand what we're doing. So the way I understand it now is we are allowed to conduct these background checks when we're dealing with folks who are working with children, elderly persons, or persons with disabilities. But if we don't pass this bill, there is a chance that as a state we would no longer be able to do those type of background checks because the federal government has said you're not going to be allowed to do them unless you put it into state statute. So do I have that correct?
Amanda Silva, for the record, that is correct.
Thank you. And then my follow-up on that is, are we at the point right now where we cannot do the background checks because we don't have this in statute, or is the concern that in the future that could happen?
Amanda Silva, for the record, we are currently conducting these background checks, and you're correct. The concern is that in the future we would not have access to that authority.
Thank you. I'll go next to Assemblywoman Krasner for a question.
Thank you, Chair Yeager, and thank you for your presentation. I'm just hoping for a clarification here. Would this apply to only convictions, or would it also apply to arrests, which might include bad arrests or arrests for a wrongful reason? Thank you.
Amanda Silva, for the record, it doesn't change what we are currently providing, so it does include both of those.
Follow-up, Chair. So I thought our system of justice was innocent till proven guilty, and so a mere arrest isn't really guilty, as we know a conviction is. And so I do have concerns with the bill. Thank you.
Okay, do we have additional questions from committee members? Let me take a look. I'm looking over to the right. I don't see any questions. Let me look over to my left. I do see one in front of me now. Go ahead, Assemblywoman Summers Armstrong.
Thank you, Chair Yeager, and thank you, Ms. Silva. Question, and this is going to go back to the previous presentation when we were talking about the collection of data for the young people. Do you all collect that data that they were speaking of previously for juvenile arrest and all that as well?
Amanda Silva for the record. The answer to that would be no, we do not include juvenile records in that.
Okay, thank you.
All right, additional questions from the committee? Assemblyman Wheeler.
Thank you, Mr. Chairman. I'm looking here and I see the 2/3 vote on here, but I don't see a fee. Is there a fee included in this, and is it a rise or higher than the fee we are currently charging?
Amanda Silva for the record. There is currently a fee that is being charged, and it's not being changed at all in this bill.
Additional questions? Right, I do not see additional questions at this time, so Ms. Silva, thank you for presenting. I'll ask you to stand by for a little bit. We'll take testimony on the bill, and then we'll come back to you for concluding remarks. At this time, I'll open it up for testimony in support of Senate Bill 19 and its first reprint. Is there anyone here in Carson City who would like to testify in support? Looks like members of our audience are hard at work on other matters and maybe not particularly interested in Senate Bill 19, so we'll go next to the Zoom to see if anybody is there in support. I don't see anybody turning their cameras on. BPS, I think we probably have some folks on the phone, so let's go there to see if they would like to offer testimony in support.
Thank you, Chair. For callers wishing to testify in support of Senate Bill 19, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 074. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you. Mr. Chair and members of the committee, for the record, my name is Charlie, C-H-A-R-L-I-E, Shepard, S-H-E-P-A-R-D, and I am the state president of AARP Nevada. A society is judged on how it treats its elders and those who are most vulnerable. It is critical that businesses or organizations that provide care or care placement services to children, older adults, and persons with disabilities are able to do thorough background checks on their employees, volunteers, and persons applying to be an employee or volunteer to protect the clients they serve. That is what this bill does. It simply establishes the provisions that authorizes these businesses or organizations to obtain the records of criminal history for screening employees and volunteers. We must protect those who are most vulnerable and prevent any mistreatment or abuse. AARP Nevada, on behalf of our 345,000 members across the Silver State, support SB 19 and encourage the committee to pass it to ensure the protection of our children, elders, and persons with disabilities. Thank you, Mr. Chair.
Thank you for your testimony this morning, Mr. Shepard. BPS, do we have additional callers in support of Senate Bill 19?
Chair, there are no other callers in support at this time.
Thank you so much, BPS. I will note for committee members, members of the public, there is a letter uploaded as an exhibit to Nellis, and that is from Mr. Barry Gold, who I believe is with AARP. And so I believe he sent that to the committee, so please do look at that when you get a moment. At this time, we'll close testimony in support. I will now open it up for testimony in opposition. Anyone here in Carson City who would like to testify in opposition? I don't see anyone coming forward. Does not look like we have anyone on the Zoom in opposition either. So BPS, let's go back to the phone lines to see if there's anybody there in opposition, please.
Yes, Chair. For callers wishing to testify in opposition of Senate Bill 19, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in opposition of Senate Bill 19, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now take neutral testimony. Anybody here in Carson City in neutral? Don't see anybody coming forward. I don't see anyone on the Zoom in neutral. BPS, could we go to the phone lines one last time for this bill and see if there's anybody there in the neutral position?
Thank you, Chair. For callers wishing to testify in neutral of Senate Bill 19, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in neutral of Senate Bill 19, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers in neutral at this time.
Thank you, BPS. I will close neutral testimony, and I will now hand it back over to Ms. Silva for any concluding remarks on Senate Bill 19.
Amanda Silva for the record. I just want to say thank you guys for your time and support, and we look forward to seeing you at the working session.
Thank you so much for being here this morning, Ms. Silva. We appreciate it and hope you have a great rest of the day. I will now close the hearing on Senate Bill 19. That moves us to our third and final bill on the agenda. I will now open the hearing on Senate Bill 359 in its first reprint. That bill provides additional penalties if a fire or explosion results from the commission of certain prohibited acts. And we have with us via Zoom this morning Senate Majority Leader Canizaro, and along with her, Mr. Heenan, who is the Assistant Fire Chief for Clark County, I believe. So if we have them queued up. And Mr. Heenan, if you could sit tight for just a moment, please. And members, just so you know, members of the public know, we're just going to give our Senate Majority Leader just a moment to pop on over. She is in the middle of some committee votes in her committee this morning, so if we could just sit tight for a moment, I don't think it'll be too long before we're ready to go. Okay, committee, we will come back to order, and I misspoke. We have our Senate Majority Leader Canizaro here in person joining us in the room, so welcome, Senate Majority Leader, and we do have Mr. Heenan on the Zoom with us. I did just open the hearing on Senate Bill 359, so we'll give the two of you a chance to present the bill, and then because we're Assembly Judiciary, you know, we're going to have some questions for you. So again, welcome. It's good to see you, and please proceed.
Thank you, Mr. Chair, and as always, love being here in the Assembly and love having the questions, actually. I think it makes for better legislation. And of course, Mr. Heenan is with me remotely. And I'm going to catch my breath for just a moment as I keep...
It's been a long week already, and we're only at Wednesday, so take as much time as you need.
Sometimes walking these days gets me a little breathless, so I appreciate the indulgence. Good morning, Chair Yeager and members of the Judiciary Committee. For the record, my name is Nicole Canizaro, and I currently serve as the senator from Senate District 6 in the northwest portion of the Las Vegas Valley. And I'm here today to present to you Senate Bill 359, which establishes enhanced penalties for illegal drug manufacturing that results in a fire or explosion. By way of background information, recent years have seen increased demand for synthetic drugs, and as a result, illegal drug manufacturing is often more common than we realize. Illegal drug manufacturing poses a significant law enforcement and emergency response issue in our state, and the actual physical dangers are overwhelmingly hazardous. The chemicals used to produce methamphetamines, for example, are highly explosive and may ignite or explode if mixed or stockpiled inadequately. Oftentimes, when these fires or explosions occur, they can be in residential neighborhoods as well, as this is where it is common for some of those operations to take place. Fires and explosions present dangers not only to the individuals who are creating the drug, but also to anyone in the immediate area, including children, neighbors, and anyone innocently passing by. This bill is fairly simple. It does establish an enhanced penalty for those manufacturing or compounding a controlled substance other than marijuana. And if a fire or explosion occurs as a result of manufacturing or compounding of a controlled substance, in addition to any other punishments, those individuals are guilty of arson, which would be a Category C felony. I will advise the committee that the intent of this bill was to create a separate offense for this type of fire or explosion when it does occur. We did work with members from the Public Defender's Office on redefining exactly what that penalty would be. That language is reflected in Senate Bill 359 in its first reprint, which is the Category C felony. And after some conversations last night, it did occur to us that potentially that language is reading as simply the enhancement piece. It is our intention that that is a separate crime. And so we're working on finessing some of that language. I would expect that you will hear from them today, that we are still in the process of working through how to make sure that that is accomplishing exactly what we are trying to accomplish. But at the end of the day, what this bill is intending to get to is where we have these illegal drug labs operating and there's a fire or explosion that occurs, that we are able to address that. Mr. Chair, with your permission, I do have Mr. Dan Heenan with us, who I would like to walk through just some of the reasons and history behind why this bill is important and why it is necessary.
Thank you so much, Senate Majority Leader. Mr. Heenan, thank you for joining us on the Zoom this morning, and please go ahead.
Thank you very much, Chairman Yeager, and thank you, Judiciary Committee, for allowing me to speak. My name's Dan Heenan. I'm the Assistant Fire Chief with our department down here. I've been employed here for 3 years in this position. Prior to that, I was a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives for 30 years. When I was with ATF, I was a certified fire investigator for 20 years, and I was the head of the United States National Response Team that traveled throughout the United States and internationally, assisting in large-scale fires and bombings. So that's a little bit about my background to understand why we were working, or why I was working with Senator Cannizzaro to bring this legislation forward. Currently, right now, if an explosion happens in a methamphetamine lab or a BHO lab, butane hash oil lab, there is no other charge than malicious endangerment or malicious destruction that we can charge. These incidents are very, very dangerous. We've anecdotally had only a handful of these in the state, maybe on the scale of 6 to 12, primarily down here in the South. But if you look at what happens in Colorado and you look at what happens in California over the last years, the BHO, the butane hash oil process has resulted in massive explosions in primarily residential areas. What this process entails is people take the scrub marijuana leaf and stems and they put them into PVC pipes, and then they push butane vapors down through, which are heavier than air, so they come down through the pipe, and in so doing they extract an oil which has a very, very high THC level. The issue is that butane is a highly explosive and it's heavier than air, so as these people are extracting it, it spreads around to the floor, and then when it hits a obstruction such as a wall, it begins to migrate upwards. If it hits any viable ignition source, such as a spark of a thermostat changing, a pilot light of a water heater, and it's in the explosive range, you'll have a massive explosion. We had one recently last month where it happened in a trailer. 2 adults were extracting marijuana, BHO, and in so doing, they blew up their trailer. This resulted in both of them being taken to UMC burn unit. A third adult individual was also transported to the hospital, and that left 2 children home alone. Fortunately, neighbors were able to take them, and we were able to get the American Red Cross and Child Protective Services involved. But this is just one incident of the things that are happening when people are trying to extract this butane hash oil and or methamphetamine or other illegal marijuana or lab productions. So that's really all I have, but I'm more than willing to answer any questions that you may have, and I appreciate the time you're allowing me to speak to you.
Thank you so much for your testimony, Mr. Heenan, and to our Senate Majority Leader. I think we have a couple of questions. I wanted to just start with one maybe for legislative intent. So the way that the bill reads, and obviously there are two sections to the bill. There's one involving controlled substances other than marijuana, and then one involving marijuana. But the phrase "a fire or explosion occurs," I just wanted to get a sense of how we are to interpret that phrase, because from my understanding of the process of I'm going to get the terminology wrong, but the process that Mr. Heenan just talked about, where you use butane, I mean, is there already going to be a fire as a result of that? So I guess I'm just trying to get on the legislative record what you mean by that phrase, fire or explosion.
Thank you, Mr.
This is Dan Heenan. Go ahead, Senator.
Thank you, Mr. Chair, for the question. Nicole Canizaro, Senate District 6. I will leave it to Mr. Heenan to talk a little bit more about the mechanics, but the intent here is that where you are operating these illegal and dangerous labs, that where there's a fire or explosion that occurs as a result of those activities, we're trying to get at those situations. And then with respect to your question as to the oil and its explosiveness, I'll leave that answer to Mr. Heenan.
Thank you, Dan Heenan, for the record. Two things can happen. First of all, there can be a fire without an explosion, and there can be explosion without a fire, although that's very rare. For an explosion to happen, you have to be within the explosive limits of the vapors. So we need oxygen, and then we need whatever the vapor is. In this case, this one instance I'm referring to, it's butane. So butane only has an explosive limit of something like potentially 4% to 9%. Anything less than that is too lean, and anything higher than that is too rich. But what also happens in some of these illegal manufacturing, especially illegal marijuana grows, where somebody is not following the laws of the land and they're doing their own grow, is that these marijuana grows take a substantial amount of energy and power to heat the plants to make them grow. And what we're seeing is that people are disconnecting, they're leasing a house, they're doing a marijuana grow within the house, and then they're subverting the energy to the meter, and they're going right directly into NV Energy's main feed. And what this causes is a massive fire hazard where the conductors and the wiring in the house is not was not designed to have that amount of energy coming through it, and it results in a lot of fires. One of the biggest safety issues with this is when a fire department comes on scene, one of the first things they do is they secure the power, and they secure the power by going to the main meter box and turning the power in the off position. That ensures that while they're fighting the fire with water, we're not going to have any electrocutions. When you see these illegal marijuana grows in which they subverted the system, firefighters who believe they secured the power then go into the fire, and they have an energized building, unbeknownst to them. And there's the danger of electrocution as they're standing in water. So that's where the fire and or explosion reference comes from.
Thank you for that response. I know we have a few questions. We'll start with Assemblywoman Bilbray Axelrod, and then we'll go to Vice Chair Wynn.
Thank you, Mr. Chair, and thank you, Senator, for bringing this bill. I just want to make sure that I'm understanding the intent of the bill. We already have in statute all of these drugs. We know that sometimes methamphetamines houses blood. We've been hearing that for years and years and years. The intent of this bill, if I'm understanding correctly, is just adding that additional marijuana aspect, because unbeknownst to me, but as has come out in this committee, that does happen. We do see explosions happening from a very specific oil, I guess, being extracted or something through the marijuana process. So am I understanding the intent correctly?
Thank you for the question. Through you, Mr. Chair, to my Assemblywoman. So this bill is actually doing two things. It pertains to where there are those illegal marijuana grows happening, but it also pertains to where there are labs for things like methamphetamines. And what this bill is intending to do is to get at where those operations are taking place, which is already illegal under Nevada law. Where a fire or an explosion occurs, we are currently unable to address that at all. And so this is adding for that particular penalty when there is a fire or explosion that occurs as a result of operating either one of these. And so it is not just for marijuana, it is, or for illegal marijuana grows, or where they're extracting the butane oil, but also if you were operating a methamphetamine lab, currently, if there was a fire or explosion that occurs, we're unable to address that, and so this is adding for where the fire or the explosion occurs.
And I guess just as a clarifying for that, I would assume you're not able to currently charge it under arson because it's not an intentional setting of a fire. It's the result of doing something else illicit, but the person didn't intend to start the fire or that caused the explosion.
Thank you for the chair, or thank you for the question, Mr. Chair. Nicole Canizaro, Senate District 6. That is correct. This type of activity does not fall under our arson statutes in the way that they are currently constructed.
Thank you. We'll go next to Vice Chair Nguyen.
Thank you, and thank you for that clarification. When I read this reprint, I was confused as to whether or not the intention was to have these two new separate charges or if one was to be enhancement. So it sounds like, just to confirm, that your intention is to work with the language so it doesn't read like an enhancement that you approve, I guess, I don't know, after sentencing. Is that correct?
Thank you for the question. Through you, Mr. Chair, to Vice Chair Nguyen, Nicole Canizaro, Senate District 6. That is correct. And that is one of the things that I did bring up that Mr. Pirro had flagged for me. We discussed last evening, and that is our intention. So I think we may need to just change a little bit of the language so that that is more clear.
And then I have another follow-up question. Is it your intent to capture like people that have like full manufacturing or compounding like labs? Or is it your intent to also include people that are perhaps staying in like an apartment or a weekly or a hotel room that are cooking, like, for lack of a better term, like individualized, like, something that they are either cooking for individual drug use. I don't know how to put that any more clear, but would these people be included in that? Like if they were in a Siegel Suites and they were using heroin and it started a fire, would it be charged under this as well?
Thank you for the question. Through you, Mr. Chair, to Vice Chair Nguyen, Nicole Canizaro, Senate District 6. No, that is not what we are trying to get at, and that's why you can see here, and when we were attempting to amend some of this language so that it was clear, we included that compounding and manufacturing pieces because we wanted to be clear that this is not, if someone is partaking in illegal substances inside of an apartment and, an accident happens in that way, that's not what this is intended to get at. This is really intended to get at what exactly Mr. Heenan was describing, which is where these are labs that are being operated. And so that's why you see it in this portion of the NRS, because that is where there is currently the outlines for, prescribing that those actions are illegal, having those labs. And so that is what we are intending to get at, not where you may have somebody in a particular apartment. We're really trying to get at those who are operating the labs.
Thank you.
Thank you. And Senator, no need to go through the chair. You can go directly to the member if you would like. We have additional questions. We'll go next to Assemblyman Miller.
Thank you, Chair. Thank you for the presentation. A quick question, something I'm just kind of curious about. How often are we seeing these type of explosions as it relates to marijuana?
Thank you for the question. Assemblyman Miller, Nicole Canizaro, Senate District 6 for the record. I will leave that answer to Mr. Heenan, who I think can provide a little bit more on the statistical data.
Thank you. Dan Heenan for the record. We have never been trying to capture this information. I've reached out to Carson City. I've reached out to Las Vegas Fire and Rescue and other fire departments throughout the state. Nobody has any actual mechanism to capture that. Anecdotally speaking to people, the BHO, the butane hash oil issue, we've seen probably down here in Clark County alone 6 times And I'm just talking Clark County Fire Department. I know City of Las Vegas has had, I believe, 2, so that's 8. But what we're anticipating is what happened in Colorado and in California, where it has really taken over on a massive scale. So they have a much larger issue. I know they're larger states, but they've also legalized marijuana a long time before we did. And this is part of the storm front that we are warned about in the law enforcement community, that these BHO labs, butane hash oil labs, are a massive issue related to explosions.
Thank you. Just one quick follow-up, Chair. And just so that I understand what's happening, when, or if this is happening, if we have actually seen it happen, where the grow house, so to speak, in the neighborhood is actually going around in the energy and tapping it, or, whatever the process that you described, where they're tapping directly, I guess, into the power source and putting too much load onto the actual electrical system within the household. We have seen those cases here in the valley, or I'm sorry, here in our state.
Dan Heenan, for the record. Yes, sir, we have. We've in Clark County Fire Department alone, we've had 3 of these incidents in the last 6 months. Somebody will move in, lease a house, and then remove all the furniture, if there was furniture, and put plants throughout the entire house, upwards of hundreds to thousands of plants. Each room will be a various stage of small newborn plants all the way up to the massive amount of large scale plants. And for them to do this, they need all the power and energy. And that's the only ones we know of are the ones we responded to because they caught fire. And that's on at least 3 occasions in the last 6 months.
Thank you.
We'll go next to Assemblywoman Cohen.
Thank you, Chair, and thank you both for the presentation. So I want to make sure I understand this. If we, and maybe Assistant Fire Chief Heenan, you might have some examples. So I'm sorry if these aren't good examples, but so if I'm doing something that's illegal but not involving drugs, and that illegal act causes an explosion, like, I don't know, doing something with chemicals, doing something with gas, right now there's no, it would just be a nuisance charge. It wouldn't, we're making this different than other explosions that happen from illegal acts. Is that what this bill would do?
Thank you for the question, Assemblywoman Nicole Cannizzaro, Senate District 6. I guess the first caveat is depending on what that illegal activity might be. But currently, under the arson statutes, if you were to set fire to a dwelling, that still requires the actual purposeful intention of setting a fire, right? So that's typically when we think of arson, and you think of first-degree residential occupied arson. That's what you're referring to. I'm not sure of other illegal acts that might result in a fire, but in theory, I think if there was some other kind of illegal act, or even under current law, if you were, manufacturing methamphetamine and there was an explosion or a fire, there is no, other than a malicious destruction of property, there's no mechanism to get at those particular acts. And so I can't think of another illegal act that either one presents the danger that these types of labs would cause or present, or that we have demonstrable evidence that is occurring. And so, we're adding this language to get at those situations, and not for just generally like if you're committing an illegal act and a fire or explosion occurs, because I think that there's a significant difference between if there were an accidental fire that occurs or engaging in some activity that by its very nature is inherently presenting this very dangerous risk and an enhanced degree of risk for fire or explosion in the way that a methamphetamine laboratory or this hash butane oil situation presents. And so you are correct. I think under existing law, unless there's some particular about that specific fact pattern, there wouldn't be a mechanism to get at that. But I think there aren't as many inherently dangerous or explosive type activities that would result in a fire or explosion as is presented with these types of labs.
And this is Dan Heenan for the record. If I may add, I agree with everything the senator said. The only caveat I might say is that there are current charges for possession of a destructive or incendiary device. So if somebody will make a pipe bomb or something like that, there is a whole separate set of charges. What we're talking about is fuel air explosions, in which the vapors of the material being utilized combine with air and make an explosive mixture. This would be absent any incendiary device like a Molotov cocktail or a explosive device such as a pipe bomb.
Okay, thank you.
Do we have additional questions? Let me look over this direction. Don't see any questions. Let me look over here. Assemblyman Ornlicker?
Yeah, thank you, Mr. Chair. I'm just curious that when these manufacturers are going in directly to the energy supply, does NV Energy not get some signal that this is going on, that they can preempt the problem we're talking about?
This is Dan Heenan for the record. No, sir. The way NV Energy tracks, they have smart meters now, and it's they record it through the meter on how much energy a house is or a business is consuming. If you subvert that and you don't go through the meter and you directly tap into it, they would get a minor spike in the neighborhood or the geographic area, use a little more power, but it's not going to be specific to one house. And that's why we use meters to identify issues like this. People in the grow houses have figured that out, and that's why they're tapping into the main system now.
Additional questions? All right, I don't see additional questions. I thank you to the two of you for presenting. I ask you to sit tight for just a few minutes. We'll take some testimony on the bill, and then we'll have a chance for concluding remarks. At this time, I'll open it up for testimony in support of Senate Bill 359 in its first reprint. Is there anyone here in Carson City with us who would like to testify in support? I don't see anyone running, elbowing, jockeying for position to get to the testifier table, so I'll go to the Zoom and I'll check to see if there's anybody there in support. I don't see anybody turning a camera on or unmuting. BPS, could we go to the phone lines to see if we have any supportive testimony there, please?
Thank you, Chair. For callers wishing to testify in support of Senate Bill 359, please press star 9 now to take your place in the queue. We will begin with caller 1. Caller 1, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Mr. Chair, members of the committee. Chuck Callaway for the record, Callaway, representing the Las Vegas Metropolitan Police Department. We have seen a growing trend with the butane being used to extract marijuana, and we have had a number of cases where people have been injured because of fires or explosions as a result of that. We are here in support of the bill. Thank you, Mr. Chair.
Thank you for your testimony, Mr. Callaway. BPS, are there additional callers in support?
Thank you, Chair. Caller with the last 3 digits of 648, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. My name is John Jones, Johnjones, here on behalf of the Nevada District Attorneys Association in support of SB 359. We want to thank Majority Leader Canizaro and Assistant Chief Heenan for bringing the bill. Thank you.
Thank you for your testimony, Mr. Jones. BPS, are there additional callers in support?
Chair, there are no other callers in support.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. Is there anybody here in Carson City with us who'd like to testify in opposition? Don't see anyone here. Is there anyone on the Zoom? I don't see anyone there. BPS, could we go to the phones to see if there's any opposition testimony, please?
Yes, Chair. For callers wishing to testify in opposition of Senate Bill 359, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 080. Caller, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hi, Jim Hoffman, Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ opposes SB 359. We're thankful to the Majority Leader for working on this in the Senate, but our group is not quite there yet. Our opposition at this point is primarily about this being a strict liability offense instead of requiring the conduct to be reckless or negligent. In the bill as written, there is no requirement that the defendant have any state of mind with regard to the fire. This is a problem because due process typically, not always but typically, requires that the defendant intend to commit a crime in order to be convicted of it. And that's not present here. The statute requires that a person have the intent to manufacture drugs, but that says nothing about their intent to start a fire. So we believe the bill as written would be open to constitutional challenge. There's also a practical concern because the point of strict liability is to encourage people to take precautions, and strict liability here would allow people to be prosecuted for someone else's mistakes or intentional bad acts. For instance, the bill as currently written could incentivize rival gangs to go around setting fires in each other's grow houses or drug manufacturing operations in order to tag their enemies with felony charges. So if the point of the bill is to encourage people to take precautions, this is undermining it because it leaves them liable even if they take every precaution. And if the point is to punish drug manufacturers for their bad conduct, strict liability also undermines that goal because it punishes them for other people's conduct. So ultimately, we're in opposition to this bill because of this strict liability component. But again, we're thankful to the Majority Leader for addressing some of our concerns previously, and we're hopeful that we can keep working on it and move out of opposition. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, could we take the next caller in opposition, please?
Chair, there are no other callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open it up for neutral testimony. We'll start here in the room in Carson City. Ms. Birchie, welcome back, and please proceed.
Thank you, Chair Yeager. Kendra Birchie with the Washoe County Public Defender's Office. I want to thank the Majority Leader for working with my office as well as Mr. Pirro on the amendment in the Senate. She accepted our amendment, and unfortunately, I think that our amendment ended up confusing the issues more, where it's unclear at this point whether it's an enhancement that's determined at sentencing or a separate charge. So we look forward to continuing to work with the Majority Leader to ensure that the language is correct to match the intent. And Mr. Pirro, I believe, will be on the phone to provide further information. Thank you.
Thank you, Ms. Birchie, and realize it's a work in progress, and I will, maybe much to his chagrin, offer our legal counsel, Mr. Wilkinson, to be able to help out in figuring out how to get the language correct, if you don't mind, Mr. Wilkinson. Thank you, Ms. Birchie. Anyone else here in the room who would like to testify in the neutral position? Don't see anyone else here. I don't think we have anyone on the Zoom in neutral. Let's go to the phone line. I think we have Mr. Pirro there and perhaps others. So BPS, if we could take the first neutral caller, please.
Yes, Chair. For callers wishing to testify in neutral of Senate Bill 359, please press star 9 now to take your place in the queue. And caller with the last 3 digits of 611, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman and members of the committee. This is John Pirro from the Clark County Public Defender's Office. As Ms. Birchie had said, we'd like to thank the Majority Leader for trying to work with us on this bill and continuing to work with us on this bill. I apologize to you, Mr. Wilkinson. You and my drafting is pretty bad, but I think we can get the intent where it needs to be and get this bill over the hump before the end of the session. Thank you.
Thank you, Mr. Pirro. Appreciate your testimony. Are there additional callers in the neutral position?
there are no other callers in neutral.
Thank you so much, BPS. I will close neutral testimony. I will now invite Senate Majority Leader Cannizzaro to come back to the table and provide any concluding remarks on Senate Bill 359 and its first reprint.
Thank you, Mr. Chair and members of the committee, again for having me here with you this morning. As you heard from both Ms. Berkshire and Mr. Pirro, we are working to make sure that this language accomplishes what we are intending to accomplish, and I'm sure that Mr. Wilkinson can certainly help us to get that in the right place. I did just want to address one item, because I think one of the differences here, and one of the reasons why this currently it cannot be charged under arson, is because what this is intending to get at is where someone is engaging in reckless behavior, where it's negligent, where it is exceedingly dangerous. So this is not a simply, if you are standing near the house and a fire explosion occurs, you are somehow criminally liable. This is where someone is undertaking the actions to engage in a particularly inherently dangerous activity where they have to be part of the manufacturing and compounding of these substances, and that by doing so, they are creating this situation where a fire or explosion is likely to occur. And so trying to make sure that we are adequately addressing that is what this bill is seeking to do. And so I think some of the concerns about this being somehow a place where either a rival gang or someone else could go around setting fires to things and thereby tag folks with felonies. Frankly, I think rival gangs are likely to pick other types of felonies to go ahead and tag people with, in my experience. But this is really where you are the person who's operating that lab, and as a result of those very dangerous activities, a fire explosion occurs, and that's really what we're trying to get at here. So I'm of course committed to making sure that this language accomplishes what it is intending to accomplish, which is to get at those actions, and also to do so in a way that makes sense statutorily. And so I will continue to work with the stakeholders on making sure that language comes out appropriately. Thank you, Mr. Chair.
Thank you, Senate Majority Leader. Mr. Heenan, did you want to make any concluding remarks before we close out this morning?
Dan Heenan, for the record. Thank you, Mr. Chair. No, I'm fine. I've stated everything I have to. Thank you.
All right, thank you so much. Appreciate both of you being here this morning, and especially our Senate Majority Leader. We know you have a lot going on running from committee to committee, so thank you for joining us, and I'm sure we will see you very soon, and have a great rest of the day. So I will close the hearing on Senate Bill 359 in its first reprint. Committee, that takes us to the final item on our agenda, which is public comment. By way of reminder, public comment is reserved for at least 30 minutes at the end of each meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. So at this time, I'll open public comment. Would any of our two folks who are still with us here in the room in Carson City like to give public comment this morning? I'm seeing heads indicating no. So let's go to the phone lines, BPS. Is there anybody there for public comment?
For callers wishing to provide public comment, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE GRANT, sister of Thomas Purdy, who was murdered by Reno police, hogtied for 40 plus minutes and then asphyxiated while still hogtied by Washoe County Sheriff's Office. It's been an emotional week. My family is overjoyed to see George Floyd's family, get justice that my family personally and so many others has been denied. My brother's case never even got reviewed by District Attorney Chris Hicks. What does that say? Everybody was outraged about George Floyd, but what about the people in your own state that have been asphyxiated to death by police? Their death is no less than any others. And I wanted to bring up something that sort of I find offensive, AB 268, Micaiah's Law. If you're going to have somebody call supporting your bill as an assembly person, you should make sure they know the person's name. It's Micaiah. And I've been speaking to Micaiah's mom, and it's pretty ingenuine to name a bill after somebody's son, but not even reach out to them personally to get their opinion on the bill or any insight from them. She's still waiting for your phone call. Please support bills that promote transparency and accountability. Thank you.
Thank you for your public comment, Ms. Grant. VPS, are there additional callers for public comment this morning?
Chair, there are no other callers for public comment at this time.
Thank you so much, BPS. I will close public comment. Anything else from our very hardworking Assembly Judiciary Committee members this morning? Okay, I don't see anything from the committee members. Want to thank you all for being here. In terms of where we go from here, we do have judiciary meetings on Thursday and Friday. They will be at 8 o'clock. I know that comes as a little bit of a disappointment, but we need to make sure we get through all of our bills. I think we have 3 bills on each agenda. I don't yet know what next week will look like. As you all know, we're going to be getting a lot of Senate bills coming over on the floor in the next couple days, so I will keep you updated on where we go from here. My guess is that we're probably going to have Judiciary Committee every day until the next deadline, but we'll see. Perhaps we'll have the luxury of being able to cancel a meeting if we can get our work done in a timely fashion. So thank you all again for being here this morning. I'll see you back in this committee room tomorrow morning at 8 o'clock. Until then, this meeting is adjourned.